The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated and welcome. Two cases will be submitted this morning. Those cases are in the matter of Mary Howes. The second case is Kelly Joe Griffin versus Paul Pate in his capacity as Secretary of the State of Iowa, and Denise Frazee in her capacity as County Auditor of Lee County, Iowa. We'll now hear the arguments in the first case. Mr. Cmelik, you may proceed.
May it please the Court. The Commission applies to this Court today for a public reprimand of Judge Mary Howes of the 7th Judicial District for conduct arising out of the grant of a temporary restraining order to an attorney who the Commission asserts she was representing at that particular time. The Commission asserts that there were violations of Canons 1, 2, and 3 in this particular case. It's important to look at the kind of time frame we're talking about in this particular case. There are two or three relevant time frames I can point out for the Court. The first time frame is the overall time frame from June 2011 to October of 2013. That's the overall length in which there was, at least in some time, a relationship between the judge and the attorney in this particular case. The June 2011 to May 2012 time frame is when there was a pending divorce, and the parties at least begrudgingly admit that there was an attorney-client relationship between Judge Howes and Maria Pauley at that particular time. The divorce ended with a decree in May of 2012, and then there was a 14-month gap when a dispute arose about the terms of the decree. So that creates the second time frame, which is kind of embedded in the entire time frame, and that is May 2nd of 2013 to October of 2013. Another time period in which the Commission found that Maria Pauley was indeed representing Judge Howes. The manner in which this representation arose was that the ex-spouse of Judge Howes contacted her concerning the interception of a tax refund and said that refund had to be returned to him or repaid to him pursuant to the decree. Judge Howes responded to her ex-husband by saying she had discussed the matter with her attorney, identified that attorney as Maria Pauley, carbon copied the communication to Maria Pauley, and told her ex-husband they would repay half the sum. Then on May 17, Maria Pauley actually received a communication from the ex-spouse's attorney regarding this particular matter. She then, apparently, there was a chance meeting in the hallway or the courthouse in which Judge Howes and Maria Pauley discussed the communication. The record's not entirely clear if this was the first communication, but I think it's fair to conclude that the letter that had represented that Ms. Pauley was representing Judge Howes was in fact not true, that she had not contacted Maria Pauley at the time, but had assumed or at least testified that she was going to contact her in relationship to this matter. But there was this meeting on May 18th in which they discussed the communication, and Judge Howes authorized Maria Pauley to respond to the communication. So on May 22nd, I think it was, Maria Pauley did respond that they were not, with the communication, they were not going to pay any of the money that her ex-spouse was requesting. So then there's a gap of some 2 months in which nothing happened on this particular matter. But during that period, on July 25th, Maria Pauley appeared before Judge Howes and asked for a temporary restraining order in a divorce modification action.
Was there some indication that there were not other judges available at the time?
There is certainly a record that said all the other judges in the courthouse at that particular time were busy. They were on the bench. It's significant that Maria Pauley appeared in a non-order hour. There were 2 order hours by local rule in which attorneys could come to judges during the order hour and get these kind of orders signed. I think it was 8:30 to 9:30 and 1:30 to 2:30 were the hours. Attorney Pauly appeared at like 10:15 or 10:30 to get the order signed. There's not a lot of discussion about, what the judges were doing, whether they were in trials, whether they were in hearings, whether they were on the bench for, any particular reason, but they seemed to be occupied at that particular time. Whether that actually means that no judge was going to be available in the near future, or there wouldn't be a few minutes before a judge would be available, or a judge couldn't be interrupted if there was truly an emergency that had to be dealt with. I think all of those options were certainly available at the time.
My reading of the record, it didn't seem like this order was even served for 2 or 3 days later.
I think that's correct, and in fact, the order wasn't sought until the day after it was prepared. So there was some lag time in which the attorney even agreed to go, or their client authorized the attorney to go and file this particular matter.
But if Judge Howe waited, if the lawyer waited till noon, an hour difference to catch someone on the noon break to spend the 10 minutes, it didn't make a difference on the service of this order or anything else.
I think that's right, and I think practically, although the record is not entirely clear, practically I don't think there was any likelihood that the child was going to be imperiled at all in that time frame.
Didn't the record show that the woman was still in India or on her way here? She was
Well,
either in Pakistan or D.C. She wasn't even in the state.
It's disputed. I think the representation by the attorney in this case was that they had reason to believe she might be in Iowa City because she had relatives there. But I don't think there was any actual knowledge of whether this person was in Pakistan, in the United States, or in Iowa City, or in Washington, D.C. And I think it's difficult in some ways to fault the judge for that, because I think the judge is relying upon the representations made by counsel.
Let me ask you this question, though, and I hate to change the subject, but there's no response from Pauly's letter. 2 months transpire. Is she still, I think the commission found she was still representing her. Is that finding, factually supported in the record, especially in light of the fact that her former husband had cashed the check and they might have thought the matter was over?
I think it's unreasonable to conclude when the matter has not been definitively resolved. There were 2 positions taken in this case. One by the ex-spouse's attorney that their proposal was unacceptable, and there had been suggestion that they were going to pursue other actions to collect that. There was then Judge Howe's position that this is what we're going to do. But there certainly wasn't any definitive resolution, and there certainly was no letter of disengagement to Judge Howe's from Maria Pauly, nor was there any kind of agreement or settlement from the other side. So I think it's a fair inference that until we definitively know this matter is resolved, you shouldn't, as a judge, sit on a case in which that attorney is actively participating.
What about the cashing of the check? Doesn't that seem to suggest that the matter is closed?
Well, there certainly has been no satisfaction filed by any party in this particular case. It certainly shows that they were willing to accept half the money, but it doesn't definitively resolve the remaining amount and whether or not that was going to be paid or not paid. And I think what you see in this case on July 31st, then there's additional communication, and there's additional communication in September, and ultimately more communication in October. So you have to see that there was a period of representation from May to October that really, despite a 2-month lag, which I don't think is that unusual in the practice of law, a continuing representation in that particular case. Certainly in this case, which I can admit is kind of odd in its factual pattern, but we have a judge who is willing to represent that Maria Pauly is representing her without consulting Maria Pauly. We have Maria Pauly who's willing to send letters on her behalf without consulting the judge. When you have that kind of a loose relationship, I think it behooves everybody for there to be more definitive paperwork or representations when that relationship begins and when that relationship ends. This kind of practice that took place in this case just creates problems.
Let's assume that we cannot find that the representation continued and it ended it has to be a reasonable time, I guess, after that May 22nd
May
letter?
22nd.
So maybe it ended sometime in June because no one got back within 30 days. But is the Judicial Qualifications Commission is that there still has to be some period before the judge can reengage? We have some cases in Iowa that talk about a year and 2 years, but.
Yeah, yes. I think there are two questions here. One is the commission took a really bold stance, I think, to suggest that we should have some bright line rule, a rule that may incorporate a 2-year time period, that no judge should sit on a case in which an attorney who previously represented them is acting for a period of 2 years.
That would be consistent with our Heckard case. where
That's
for
exactly
2 years.
consistent with Heckard. Now, Heckard's a little bit vague in its time frames. It says something less than 2 years, but the suggestion is it was up to 2 years in that particular case. And it's also a case about disclosure, not recusal. And I do want to make one comment on that. The Iowa Practice Series article or secondary source authored by Justice Cady talks about there being no definitive case law in this state that says the failure to disclose is something that is sanctionable. It's the failure to recuse yourself when indeed you should. But I want to suggest that maybe that doesn't make much sense.
Well, it probably doesn't make much sense, because if, in our cases, when you failure to disclose, we not only had Heckard, we had Forsmark. When you failure to disclose, they gave people new trials.
And that's exactly my point. If you look at Krull, one of the things this court said in Krull is if the judge doesn't act appropriately, in that particular case, it was a criminal conviction was voided, and in that case, not even able to retry. But in this case, again, in Forsmark and in Heckard, you're talking about parties having to relitigate the matter because a judge didn't disclose a potential bias.
Let me ask other question before your time's up. There is a ruling from the State Bar Association dealing with this problem, and it predates when the Supreme Court took over the discipline and moved to here from the Bar Association, and that says 1 year. And the Bar Associations gave an opinion to lawyers based on the rules that you shouldn't appear before someone for 1 year when you represented them. What's the Judicial Qualifications Commission thoughts about that?
Well, I think their thoughts are certainly 1 year is not enough, and as they suggest in this case, it should be 2 years. And as we've discussed, that's not without authority. There is the Heckard decision that suggests that within 2 years is recent representation. There's also the New York Advisory Committee's recommendation of 2 years. There's Supreme Court Rule 7 that says 2 years. There's the Hollister case out of the 8th Circuit that says 2 years. So they're building on a body of case law.
There's the Utah case that said 6 months, and there's another case that said
Admittedly.
Some states go as low as 6 months.
But I think what the commission's position would be is that what the disparity in all these different states says is there are reasonable time frames, and 2 years is a reasonable time frame, and it's one that this court should adopt.
Why would we adopt that here when, it does seem that at least in May, or at least within a couple months before, she was representing the judge, Maria Pauli was representing the judge. So why would we do that? If we were going to proclaim a 2 years, wouldn't it be better to do that with rulemaking?
Well, I certainly make the alternative argument in this case that the 2-month time frame between May 22nd and July 25th is too short, and that in this case it was appropriate to find, even if the representation had ended on May 22nd, sitting on a case with that attorney a mere 2 months later is too short, and it warrants the sanction in this particular case. I suppose, why would you do it? To send a clear message and create a bright line rule that the integrity and the impartiality of our courts is something that we view very importantly in this state, and we want to create a bright line rule.
But we don't have all the information here on that today. I mean, we just have two parties in front of us. Shouldn't we allow the bar and others to comment on a proposed rule?
You certainly could, and I wouldn't say that you shouldn't wait for that to happen. And again, that's why I do make the alternative argument in this case that you can look at a very much more narrow time frame here, that being May to July or May to October, which we submit represents time frame in which the attorney was currently representing the judge in this case.
What about the free legal services? Tell me why you think that violates our gift law.
Well, I think it's the plain language of Canon 3. There's a lot of discussion in the record below in this case about the gift law. And I follow the gift law and I obey the gift law. Well, we're not talking about the gift law in this case. We're talking about Canon 3, which is something different than the gift law. What it talks about is receiving something of value that could call into question the impartiality of a court. Receiving free legal service is certainly something of value.
But let me raise a question about that. I mean, under the rules, it's permissible for a judge actually even to sit on a case where an attorney has made a substantial contribution to the retention of that judge, the campaign for the retention of that judge. Now, don't you think that that is something that might raise more of an issue than here, especially where the judge would be recused from sitting on the matters of an attorney who has provided free legal services to her?
Well, of course, in this particular instance, we don't have a history or record of recusal based upon these gifts that were given and the practice that exists in Scott County. But I think it's quite the opposite, actually. I think people have begrudgingly accepted in this country that there are donations to campaigns that are made, by PACs and by organizations and by individuals that might not directly influence a particular, in this case, judge's action. But when you talk about directly gifting somebody, in this case free legal services, it's hard to question the impartiality. I mean, it's not hard to question the impartiality of the court. How would the other party in this litigation feel about the fact that their opponent was receiving free legal services?
Mr. Cmelik, would a lawyer compromise his or her advocacy by accepting legal services without compensation?
I think that's not really the issue. The issue is whether a member of the public...
Does this have other consequences other than this case if we go down that road?
I don't think so. I mean, I think what we're asking the court to find is that a reasonable person could conclude that a judge who's received free legal services, maybe on multiple occasions from an attorney, really should disclose and ultimately recuse from a case that involves that particular attorney.
Different from the argument the commission made. As I understand what the commission said is free legal services from attorneys to judges should be disallowed completely.
Well, I think that indeed...
regardless of whether the attorney is allowed to appear in front of the judge or not.
I think that is indeed their position, and I think it's because of the consequence it creates and whether or not we're going to have disclosure and whether or not we're going to have recusal. It's a cleaner system to not have that taking place.
But a judge could take free legal services. The problem is the lawyer shouldn't appear before him. I mean, I think that's where maybe the line should be drawn.
Well,
what's the problem with that with the commission?
Except the rule says shall not accept anything of value if it calls into question the impartiality of the court.
But if you're not a restricted donor, where you're not going to appear before him, it will never call in the question because they're never appearing before him. Plain and simple.
Well, I think plain and simple is the language of the rule, however, that just makes it, it just precludes it, period.
All right, you may sum up.
Well, thank you, Your Honor, and I do ask that you accept the recommendation of the commission.
Mr. Lederer.
I always forget that this is tilted and I can't see my screen very well. Good morning. I'd like the record to reflect that Judge Howes is here with me this morning. She wanted to be here. I'd like to talk about the second issue because I'm afraid that I'll lose my time if I don't. I think the rule 51.313 is very clear. I don't mean to suggest that that means that there's no problem there. But if you look at 51.313C, you see that it says a lawyer may provide something of value if that lawyer is already going to be in a case that's pending or is imminent. And so if you give a judge something of value and there is no pending case, then there's not a problem. It would be inappropriate for Judge Howes to preside over a matter during the providing of the free legal services. That makes sense. But whether it is a contribution to a retention campaign or whether it is the providing of free legal services, the Commission's proposed rule that once you make that gift, you can never appear in front of that judge, or that judge must always recuse, has no support in the rule, because the rule talks about pending or imminent.
Letter C only applies if A doesn't apply.
And that's
And A applies and says if a reasonable person could question the judge's impartiality.
Absolutely.
And that's the first issue here.
Absolutely
And
true.
are you saying that if some lawyer gives some judge free legal services, that from a reasonable objective standard, that that person would not question the judge's impartiality?
What I'm saying is that there has to be a basis for complying with C without automatically violating A.
There is. You don't appear before him.
For how long?
We know in Heckert, the court said 2 years, because failing to disclose in a 2-year period caused, well, they said it wasn't prejudicial there, but if you read Forsmark, where it was prejudicial, they give a new trial.
But that's failure to disclose and not recusal. And I see a difference, respectfully.
Well, the reason you disclose is so you can make a recusal motion.
Yes.
I mean, so how do you say they're different?
I do. I just do. I just don't see. This case is about recusal, and it's about recusal on a matter that my expert, Mark McCormick, said was of the holding in place variety. It was not a substantive matter. There is no contrary testimony to that in this record. There's been talk about the emergency, whether it was an emergency or not. The commission and this court should look at what Maria Pauley and Judge Howes had in their minds at a moment when Maria Pauley was asserting in good faith an emergency request. At that point in time, neither one of them had a basis for concluding that there was still an attorney-client relationship, and they were under the gun. We can argue after the fact on a Monday morning whether or not they should have picked up the phone and called Chad Kepros to say, hey, is this thing still hanging fire or not? But that's not the real world of that moment, where Maria Pauley is there because her client has said, my wife is coming to take the child.
If it was such an emergency, why didn't the lawyer show up at order hour? The things were signed the night before.
And I don't know the answer to that, and there's nothing in the record to explain.
Couldn't you infer she wanted to go before the judge who she was representing?
You could infer it, but the record is without contradiction that she went to each and every other judge first.
And the record is without contradiction that she did not go to the court administrator who was in the building to see if someone could be available in the situation.
That is true. That is true.
Is the record also uncontroverted that any other judge would have signed the same hold-in-place order?
No witness testified that, no judicial witness testified that they would have refused to sign the order. They all testified that they would sign the order because, as with what McCormick said, it was a hold-in-place order and under emergency circumstances. The other thing I want to say about that whole process is that we're talking about testimony versus behavior. And what you have here is behavior that occurred before anybody went under oath. And that behavior is the most important piece of evidence in the entire case. And that's what Judge Howes did when she thought that Maria Pauley was her lawyer. She went to the court administrator and she said, I'm getting divorced. Maria Pauley is my lawyer. I cannot preside over any of her cases. That includes Scott County. It includes any other county in the district. Please make arrangements to be sure that her cases are not assigned to me both in Scott and outside of Scott.
Didn't she also say for the year afterwards, if I remember right, not just during the time period?
I apologize, Your Honor, I don't remember that. If it says it in the record, it does, but I don't remember that one way or the other. But the point is, even after all of those instructions, of course, mistakes happened, and she found herself on at least 2 occasions in an outlying county and looked at her calendar and saw that Maria Pauley was appearing as counsel of record in one of those cases. And what did she do? She refused to hear the case. She told the lawyers, I can't take this case. I'm calling court administrator to ask that it be rescheduled. I'm sorry. That tells you that you have a judge who understood her obligations when the lawyer was representing her. The fact that she signed the order in July, the ex parte emergency order, tells you that if she thought that she was still being represented by Maria Pauley, she would not have signed it.
Counsel, would you weigh in on the period of time of disqualification after the representation? What's your view about that?
I'd be happy to, except the first thing I would say is the last thing this court should do is adopt a black letter rule in the context of whether or not to represent a sitting judge. This is not the time or the place to do that. But in the bigger picture, I happen to think that Iowa has done it the right way. For as long as I have practiced, I have seen a variety of judges handle the recusal decision on a personal level based on their personal judgment about how long would they recuse for one of their former law clerks. How long do they recuse with respect to a party who was represented in their old law firm, but not by them personally? All of these things, there's just an infinite variety of circumstances that plays into this. And a black letter rule is easy, but it really doesn't grant to the judge the ability to make a prudent decision. And so I would advocate that there not be a black letter rule. But clearly, if this court wants to avoid problems by adopting one, by all means do so, but not at the expense of Judge House. That's just not right.
On our de novo review, why should we find that there was no attorney-client privilege the day of the ex parte injunction order?
Because Maria Pauley's letter, which was sent after, with all due respect, after she communicated with Judge House, told Chad Kepros, counsel for the ex-husband, she's already sent him payment for half. This matter is closed. We're done here. And that was met with 65 days of silence.
That doesn't mean the other side's going to agree to that.
Of course not, but seriously, does Judge House and or Maria Pauley have to pick up the phone on July 25 and call Chad Kepros to find out if it's still hanging fire? In my view, respectfully, no.
I think with divorce cases that continue to go on and on and on, this came up a year or two later after the final decree, and no satisfaction was filed, which is required in order to satisfy the decree and satisfy the obligation. There is an open question as to whether or not this matter is closed. Was there anything in the record that Judge House knew her ex-husband was traveling overseas for 2 months?
There's nothing in the record on that. I believe that was a surprise at the time of the hearing. I don't believe that it is fair, and I say that word thoughtfully, fair, for Chad Kepros, who's a good lawyer, good judge, to sit on that letter for more than 60 days and then say, well, we just hadn't decided yet. If Maria Pauly's letter is not acceptable and he's going to encounter some delay in responding, an Iowa lawyer's obligation at that moment is to say, I will get back to you on this, but there's going to be some time passing. If that happens, we're not here today.
Can we consider the finding made by the Grievance Commission in Maria Pauly's case that made a finding there was no attorney-client relationship on the day of that ex parte hearing, and exonerated her of any ethics charges and dismissed those charges as unproven? Can we give that any weight?
Well, it's not preclusive in this matter. And honestly, I don't know whether there's any case law on whether or not that can be considered. Because of the way our process works with respect to the discipline of judges, at this stage, this is public. The damage has already been done. There's absolutely no evidence in this record of evil intent, malicious intent, an effort to gain financial advantage at the expense of her position. Judge Howes is here because I'm asking that you do not publicly reprimand her. She's had an extraordinary career of contributions to the system of justice in this state for more than 25 years. She's been a lawyer for more than 35 years. Her record is clean. And I would ask the court to consider that this is not an appropriate record for imposing a public reprimand. Thank you very much.
Mr. Lederer, thank you as well. Rebuttal argument, Mr. Cmelik?
Thank you, may it please the court. I'd like to address this issue first that Justice Waterman brings up about what other judges testified into this particular case. One thing I think we can controvert that record because it's a legal conclusion, it's not a factual matter. And this court can decide for itself as legal scholars whether or not this injunction should have been granted. But I mean, that's not really important. I mean, in Kroll, there was testimony that any judge would have granted the warrant because there was probable cause to grant it. That didn't protect Judge Kroll from sitting on a case he shouldn't have been sitting on. So I think that really is not that important of a matter in this particular case. And I also want to just emphasize once again, even if the relationship ended on May 22nd, when that letter was sent from Maria Pauly, a judge should not hear a matter presented by that attorney within 2 months of that relationship. And that's what we have if you accept that position, that a mere 2 months later you can sit on a case in which an attorney had represented you. And that's what Heckert says we can't do. Another thing that should cause pause is if you're sitting on a case 2 months later, do you have a duty to disclose? And if it's an ex parte hearing, how are you going to disclose that? And if you can't disclose it, should you be sitting on the case? And I think that resolves the question in this matter. That you, in a situation where you cannot disclose, you shouldn't hear it. So for those reasons, we would ask that you do affirm or adopt the recommendation of the commission. Thank you.
Thank you as well, counsel. The case is now then submitted, and we'll hear the arguments in the Griffin case.